illiquid stock options. Thank you all for joining in our journey and encouraging and motivating us in our knowledge sharing endeavors. According to SEBI's finding, up to 14,720 entities had engaged in generating artificial volume by executing non-genuine reversal trade from 1st April 2014 to 30 September 2015 in illiquid stock option at BSE. After SEBI Settlement Scheme 2020, which did not get the expected reaction and the rigmarole that followed in, SEBI has now reintroduced the Settlement Scheme 2022 to provide another opportunity for settlement to the entities involved. The scheme is available to entities against whom proceedings have been begun and are pending before any forum or authority such as court, SAT, adjudication officer, and recovery officer. The scheme opened on 22nd July 2022 and will end on 21st November 2022. Critical area for discussion today will be how to avail the Settlement Scheme 2022, how settlement amount is derived, whether selling would mean admission, whether settling or accepting the settlement scheme would mean admission of yield, consequences of availing or not availing the Settlement Scheme 2022. All these issues we have to discuss today. Today we have eminent speaker for today's webinar, Ravi Prakash. He is Associate Partner, Securities Law and Corporate Litigation and Corporate Professional and working in Securities Law Advisory Services. Ms. Nikita Vijay, she is Senior Associate, Securities Law and Corporate Litigation, Corporate Professional. They both have handled various cases of adjudication as well as settlement, and especially the old scheme settlement they have settled, and now as per the new settlement scheme, they are handling various cases. So these are the two people who are experienced, who knows things, and they are aware of various aspects and various nitty-gritty. So friends, before starting and the technical part, I want to give you certain the issues, because sometimes we are not clear that what are the issues, what is illiquid option, how the reversal is taking place, how the reversal mean, all these things are there. So today we will discuss these things. So I'm just starting this, that what is the SEBI Settlement Scheme 2022, reversal trading in liquid option. So as you understand that whenever you are doing any business, because you have to understand jurisprudence of this particular transactions. So whenever we are doing any economic activities, this is in resulting either loss or profit. So you have a profit and then you have either you have a loss. These are the two things which we have to understand. There is no other third way that you can do other things. So these are the economic activities.
Recording in progress.
So we have to understand the legitimate tax planning is allowed under the law. So I just told you that whenever you are doing any economic activity, there is a profit or there is a loss. But there is some other way also where you can do tax planning, like few legitimate way where you can do like genuine business expenditure you're doing merger and acquisition, then you can do tax planning. There is a genuine losses in the company. If you are doing demerger, then there are certain issues where you can take advantage of the tax planning. You're doing investment and you are getting profit or loss, and genuine trade in securities market. These are the few legitimate way by tax planning that is law recognized and law accept, and then you can do that work. But if we see the other part, then in what basis law punishes illegal tax planning, that is called avoidance. Planning is good, avoidance is bad. So few example is that you are just booking bogus expenditure. You are doing, you are reducing your sale. You are booking fictitious losses. So somebody has profit and you are booking fictitious losses. Now, these are the things which are normal accounting part. Now come to the non-genuine trading in securities market. which is our today's concern. The old method was booking illegal long-term capital gain, that you have purchased something and then after some time you have sold the same party and then you have booked the long-term gain. Fictitious trading at SME platform, because so many people are doing fictitious trading in SME platform. Then trading in penny stock, having no strong fundamental, but their share prices started from 10 rupees and reached to 500 rupees. And various people have taken advantage of this manipulation by converting their long-term gain. These are the old method, but new method is started trading in illiquid stock option, which is the today's matter where we want to discuss. Now we should understand what happened in the illiquid stock option matters. So this is very essential to understand. Number one, the trading pattern in illiquid stock option, because whether trading in liquid stock option is bad, no, it is not bad, it is allowed. But the trading, if you are doing these four things, parties get involved in reversal trade, mean buyer and seller. One time I'm a buyer, next time I'm a seller. So these are the trades which are reversal in nature. Trade enters by one party, but reverse either on the same day or next day. So Mr. X has purchased and next day or the same day he has sold also. The trade were executed with the same counterparty. So both the places to whom you are selling, next time you are buying from the same person. Substantial price difference without any significant basis for the change in current contract price. Now what is happening? The price is say 10 rupees, now it is 90 rupees, and then again it has come to 10 rupees. So you have, what you have done, you have shifted, which I will show you with the example. Let's understand how. Now, how the anonymous trade is executed in the market. So before understanding this, that how the trade people are doing, you should understand the basic concept of how the market operates in normal circumstances. Here, buyer and seller do not know each other. Buyer and seller enter the price quantity in the system, which you are normally doing trades. You are just feeding. You don't know who is the buyer. You are just seeing the rate, whether it's suitable to you or you are doing market rate. That is there. So buyer and seller enter the price quantity in the system in normal way, and the system matches the order having same quantity price in the trade is executed. So system, it generate that which is the maximum possibility of matching that trade will execute. But interestingly, here whose transaction is matching with whom, nobody knows. This is the system matches the system, and I'm not aware that my share which I have sold, say 100 shares, how many people have taken, maybe somebody has taken 100 share or somebody taken had 5, 10, 20, 30, any number. Now, investor execute, go back, next is the investor executed these transactions, these trades that are visible in the order book but do not reveal their identity. So investor will get that I'm buying some shares 35 rupees because that is visible, but he is not aware that who is selling at 35, who's selling at 36, who's selling at 37. So he is executing trade on the basis of order book and the amount. Then settlement is done by the system, and beneficial ownership of shares get changed immediately by the system. So this is the genuine system which is following, where this is called anonymous system. Now I'll show you that how this system people are manipulating and how the system is they are doing. So we have to understand there's a popular term in the stock market that's called 1, 2, 3 transaction. So this reversal, synchronized trade, whatnot, they are all synonyms, and there is one popular term of stock market is 1, 2, 3 transaction. Now, how the 1, 2, 3 transaction takes place? Here, buyer and seller know each other. Both are aware that I am feeding, you are feeding. So buyer and seller punch the same price quantity at the same time. So both the parties, they are having a telephone from both the side, like which we are seeing in the army. Then when they are fighting, they have a wireless system where you have reached, where is the next place and what is the time. So same thing they do. They have a telephone buyer and seller punch the same quantity, same price, and same time, and they keep it everything ready. So what is happening? The system recognize the maximum matching. So here what is happening? All three things mean price, quantity that you can match. Now here the important is you have to match the time also. So time matching will take place when both the parties feeding transaction at the same time. So when you are feeding this way, the chances of executing trade with each other increases to 90%. So it is not that 100% your system will match, because sometimes other transactions are also there. So that can also take, but there is a possibility that 90% time the transaction matches with the same buyer and seller. Trade is executed as per pre-arranged things. Parties knows with whom the trade got executed, and then done with the intent to especially increase the price volume of the particular security or shifting the profit. So this is the basic understanding of 1, 2, 3. So you just keep the phone, both the parties ready, and then they are saying 1, 2, 3, and then they click. So as soon as they click, the transaction will go inside the system, and system will match because all three things are matching. So first priority they will get, and the transaction will match. So the anonymous system is there, which is saying that nobody should know each other, and that is the system. But here I am doing the transaction knowing that this is going to X, I am selling to X, and then X is selling to me, which is coming to me, and the price difference is the main culprit here. So this is the 1, 2, 3 transaction which people are manipulating. Sometimes somebody say, what is the problem in this? The problem is that SEBI doesn't allow this type of transaction, which is called artificial synchronized transaction. So to understand this, A bought 10 shares of rupees 72 from B. Same day or next day, A sold 10 shares at the rate of 22. So what A has done, he has purchased at the rate of 72 and then sold it at 22. So A incurred loss of 500 rupees and B incurred profit of 500 rupees. So these above said trade are done repeatedly by the parties. They buy and they sell, they buy and sell. So this B wants to get something because he has to take capital gain, and A has profit in this, so he requires losses. So they transfer. This is a illegal transaction as per Income Tax Act also, as per SEBI Act also, as per other authority also, because there are various authorities like ED and other thing. They also see if there is a violation of SEBI related law, then ED also involved, because you are doing illegal trade. You are part of the scheduled offense, and in the scheduled offense you are doing some transaction that where the money laundering is also involved. But today we will confine to the income tax and these things, because this scheme gives lots of leeway which was not available with the earlier scheme. Now I will request Ravi to tell about the illiquid stock option, how this has taken place specifically. I have told the macro view. Now Ravi, come and tell the specific point of this illiquid stock option, how this has taken place, what are the things. So after the Ravi will give you the entire thing, then Nikita will cover the how to fill the application, what are the issues you have to take care, and what are the points which we will do, and then we'll have a question answer. Over to you, Ravi. What is the illiquid option and why this scheme of first scheme is not successful, why they have turned out second scheme and issues in second scheme.
Thank you so much, sir, for giving us a very good head start. I hope I'm audible.
Yeah.
Very good evening to all in the audience. And so let us quickly start. What is a liquid stock option? Let us break this into two. One is that these are stock options. Stock options, as you understand, is a derivative product. It's a derivative contract which is floated on the stock exchanges, and it is in the market for almost 2 decades now, or maybe for over 2 decades now. So while the concept of stock option is clear, let us understand what is this illiquid stock option and how this entire fiasco came into being. One is that illiquidity is an aspect of when you cannot convert the asset or security which you possess or you own into something more liquid asset. Usually liquidity is defined or meant in the conversion, the time you take to convert it into cash or money. So it means that illiquid stock option does not have a very ready market where people are ready to buy it or sell it from each other, and the market is sluggish. And as you see on the screen, illiquid options had very low or near to no open interest, which again mean that the market participants were not evincing the interest as they were in other stock options. So we had a stock options platform on NSE also, which is the most frequent. I mean, that can be called a very highly liquid platform where stock options are being traded very frequently. And it is a common knowledge that it is the option which contribute to the volumes, significant volumes of the market that we see every day. Nikita, can we switch over the page to the next slide? So that is for the illiquid stock options, means stock options, that is the derivative contracts, which are illiquid or have the characteristic of illiquidity. Now, next, going forward, let us understand what are reversal trades, because as sir mentioned in his plenary, that it is not the illiquid stock option which is the problem, because it was just a product which was listed on one of the stock exchanges. The problem started when the authorities begin to observe that there were frequent reversal trading in the illiquid stock options. Now, what is this reversal trade? As the name itself suggests, these are the trades which are reversed. It means a person, a market participant who's entering into the market as a buyer, he would change the plank and he would become a seller. So who's a buyer today, he would become a seller today. Now, one would question that this is a very normal phenomena. One who goes into the market, he may buy, and thereafter, after buying, he might wish to sell the product. And that is how you convert your assets or securities into money. That is good. But what happened here is that these transactions were done without any economic rationale. As you saw in the example, Nikita, can you take to the example on the slide number 9? So if you see the example on slide number 9 that we are putting on the screen, you see that A is buying 10 shares at rupees 72. And then in the very next instance, A is selling the same 10 shares at rupees 22. Now, if you do not see this example and see this phenomena in its abstract sense, that A is buying and selling, there is no problem. But if you see these figures and facts, the problem starts to emerge before your eyes. Now, obvious question that emerges before you is why this man A or this person A would sell something at a loss of 50 rupees the very next moment he bought it. There is the problem. And this is not the one instance. I mean, we could show only one instance because it is enough to understand it, enough to give you an understanding of what SEBI perceives as a possible regulatory problem, or a problem that cut across the roots of their system, which interfere with the integrity of system. Now, I'll take you to the part of integrity later on, well, as I speak. But let us understand, A buys some share at X price, which price is, let's assume, 72 rupees, as shown in the example. And then he sells these shares at rupees 22, which is 50 rupees lesser than he bought at. So he's incurring loss of 50 rupees. And this he does repetitively. Now, the regulator was quite troubled by this. They saw that why would any person would buy and sell at constant losses, and how the counterparty is making profit consistently. And these are, to mind you, these are the same persons, same party and same counterparty, changing positions. Now, Nikita, can we go forward to the slide number 11? So let us see the characteristics, the basic characteristics of reversal trade, or that there could be a deep-rooted scheme behind these reversal trades, but let us see what are the essential characteristics. One is that these would always be done with synchronization, which is also called the element of pre-planning, because without pre-planning, you cannot sell to the same person or buy at the specified rate. Your plan would get interfered by other market participants. But since this was illiquid stock options, which means it has low or near to no open interest, there were less market participants. This was a lucrative area for the people or for the kingpins who devised this entire scheme, for the people to join here and do this kind of reversal trading. Now, of course, when there is a pre-planning, the element of pre-planning, there would be pre-identified individuals or identified persons on both the ends. So it means the counterparties or parties are identified. They might not be known to each other, but they are identified. Third is within less proximity of time, because of course, if you want to reverse it, you would want to do it as possible as you can, so as to achieve your targets of converting losses or profits artificially. And because there is a reversal happening, and all that is pre-planned, and that is not for the genuine, that is not done with the genuine intent of exchanging money for some utility or service or good, it is natural that it will result in artificial volume of trading and artificial price of the securities in which people are trading in this manner. So in result, what happened is, number one, when the people entered into the market in illiquid stock options, I'm not commenting whether these people were known or they were aware of what they were involved in or not. That's a different question. I'll come to that later on. But let us see what violations are triggered when they entered the market. So the moment they entered the market and the moment they did synchronized trade, that's the first violation they committed. Although synchronized is not a violation in itself, it has been held by courts that merely synchronizing is not a violation, but synchronizing with intent to cause artificial volume or artificial pricing, which is a manipulative trade, is illegal. Second is that because these people did not conduct the trades with economic rationale, it follows that the endeavor was to artificially create volume and artificially create the price. Artificially affect the price. So in this illiquid stock options matter, the prime allegation of SEBI is this, that parties entered into market, they conducted reversal trades. The reversal trades were without any economic rationale. And these are what this is what SEBI quotes in the SC, their show cause notices, which have been issued to multiple parties. And their reversal trade with no economic rationale resulted in artificial volume of trading and also affected the price. So what is an artificial volume? An artificial volume can be understood from the very same example on slide number 9. Nikita, can you please take us to slide number 9? Now, let us understand, before we get into the example, or to understand what is an artificial volume, let us understand how the concept of money works. It would appear to you that these two are different things, but these are connected and inherently connected. You see, whenever you spend some money, whenever you exchange some money, the exchange usually results in the person who's spending the money. It brings some utility, some product, some good, or some services to that person. So if you spend money, in lieu of that spending, you get some utility, service, or product, or some value. And your spending becomes income of someone else who is giving up on the good, utility, service, or value, which he's providing to you, or he's acting as an intermediary in providing you that good, service, utility, or product. Artificial, the element of artificial, trading or artificial bargain with money comes into play when you are putting money, and in lieu, you are not getting anything. Let us see how. this example or this concept fits right in this example, which is at slide number 9 before on the screen before you. So A bought 10 shares at rupees 72. There is, of course, no economic rationale for A to sell those shares at an extreme loss of rupees 50 at the very next moment or very next day. And he does not, A is not doing it just once, A is doing it repetitively. So this element of repetitiveness adds to the grave suspicion that not only the suspicion, but in fact, a conclusion, a logical inference that there is no economic rationale in these transactions. So it means that the money is being spent not for any economic utility or good or value or product, but it is being spent to artificially reflect that some kind of trading is happening when there is none. So this is artificial volume. So A bought 10 shares, this resulted into volume of 20 because B is selling 10 to A is buying 10 from B. So it gets 2x. And because A again sold it to B, it 20 more. So by buying and selling 10 from A and B, and this to and fro between A and B, it results into the volume of 40, which is artificial because there is no element of genuinity, or it is not backed by any economic rationale, prima facie. Can we go to slide number 12, Nikita? Now, to support, to showcase how the courts have viewed it, let us remember the judgment passed by Supreme Court in Rakhi Trading Private Limited, which was appeal number 1969 of 2011, decided on 8th of Feb 2018. The Supreme Court said that usually a person would trade with an aim to make profits. But if one party is consistently making losses, and that too in a pre-planned and rapid reverse trades, it is sufficient that the trade is not genuine and is an unfair trade practice. So this is the linchpin of SEBI's argument in the entire gamut of illiquid stock option matters, that we see no economic rationale. There is an element of pre-planning. There are rapid reverse trades, and these are done with an intent to unfairly trade in the market. Rather, these trades have messed with the integrity of the trading system. Can we move on, Nikita, to the next slide? As I told you, these are the observations of SEBI. They are boiled down to 6 pointers, which are these: that the parties misused the anonymous trading system, which is interfering with the market system or integrity with the system. That SEBI calls its hallmark, because anonymity ensures that no one is able to capture any unfair bargaining position in the market. That's what anonymity ensures. Anonymity also ensures that you are dealing in the securities, not choosing the preferred person who to deal with, or not, and so that people do not synchronize and play in the prices and volumes of the script. They only trade with the genuine intent of exchanging an economic bargain in the securities. So the parties acted abnormally, as I showcased you and Sir showcased you through the example on slide number 9, that there is no economic rationale in consistently making losses, buying at 72 and selling at 22, incurring loss of 50, while your counterparty is always making consistent profits. Then trades reversed with a pre-arrangement with the counterparty. The pre-arrangement is not on paper. It is not something which is led by evidence by the SEBI. In all fairness, I must put it on record. This is a logical inference because there were rapid reversal trades between two parties who were switching positions. It is inferred by SEBI, and that can be legally inferred by SEBI, although I'm not commenting on facts and circumstances of each cases, but legally it is permissible for SEBI to take an inference based on the established principle of preponderance that the parties are acting in an abnormal manner. And in fact, the conduct of parties shows some kind of unfairness or manipulative intent. So the trades are reversed within short period of time, which is of course the case. As in most of the cases, after a few seconds, after a few minutes, few hours, or in some cases on the next day, the trades have been reversed. The trades reversed at differential pricing without having any basis of such increase or decrease. That is also an important point, that apart from incurring profits or losses whatsoever, there was no corresponding change in the contract price, and the buyers and the market participants were doing it. And one of the participants, as discussed so many times by now, he was doing it at such a prices which did not showcase any economic rationality behind such prices, and that these trades are non-genuine and aimed at creating fictitious losses or gains, which is represented because you have created an artificial volume or one has created artificial pricing. So therefore, the losses or gains, those are generated by engaging into rapid reversal trade. They resulted in fictitious losses or gains. That is the claim of SEBI. Can we come to the next slide, Nikita? I think it is slide number, yes, the next slide. Correct. So let us understand under which provisions of securities laws the entities have been charged. On your screen right now are the provisions, the gist of provisions under which the entities under these illiquid stock options matters are charged. This is Regulation 3, Regulation 4, Sub-Regulation 1, Regulation 4, Sub-Regulation 2, Clause A. And just for your understanding, we have simplified into the following categories. The above mentioned provisions, they consider any of these categories which are on your screen as fraud or manipulation. One is that if one buys or sells or deals in a securities, to mind you, dealing in a security is a wider word than buying or selling. A gift might not qualify for a sell, but it might qualify for dealing in securities. A broker does not buy or sell in his own if he's trading for a client, but he's certainly dealing in a security. So dealing is a wider word than buying and selling. A pledge is also considered to be dealing in securities. So if one is dealing in securities in a fraudulent manner, that's also a fraud. If one devises any manipulative or deceptive scheme, that is also a fraud. If any device, scheme, or artifice to defraud in connection with securities market is employed, that is also a fraudulent activity. Any practice, any act, any course of business which operates or would operate as a fraud or deceit upon any person in connection with securities market, that would also be a fraudulent activity. Knowingly indulging in an act which creates false or misleading appearance of trading in the securities market, that's also a fraudulent activity. Now, the keyword is knowingly, with the element of knowledge that you knew what you were doing. And previously I stated that I'm not commenting whether people knew it or not, because this is one kind of a scam which has reached to a very retail level. I mean, you pull up any metro city starting from Kolkata, Delhi, Mumbai, Gujarat. I mean, you see these cases. The roots of this kind of cases have spread across all the almost all the tier 1 or tier 2 states and cities. And a lot of households, sometimes entire family, have these kind of cases coming from SEBI. So certainly it comes into my mind that there must be someone who connected the dots all across the country with this kind of a scheme that people can trade. And I'm not sure, or I'm not sure how much, what was the extent of knowledge that these people possessed. And I'm sure that many of the people who received notices from SEBI, they must be wondering what happened. Because in my first-hand experience, I was told by my clients that they did not know about these, and these were done by some agents who came to them and told them that this is a good investment opportunity. And you know that earlier as well, there were a lot of solicitation done by people in street, the agents of certain intermediaries who claimed that we are the agents of so-called intermediaries of the market, and we will put your money where you will get decent returns. And there have been instances, and SEBI is so well aware of it that SEBI has launched its campaign more than a decade ago to educate investors across the country. And they have their regional offices set up for that purposes. with time, regional offices were given more powers, more functions to discharge, but the primary reason was to spread investor education. So knowledge is the element you see in one of the categories, but the real challenge here is that Supreme Court, while they were deciding one of the matters, they pronounced that a pigeonhole approach, a pigeonhole theory cannot be applied while fastening the charges of fraud, because SEBI does not know under which exact laws a fraud has been committed. So if they allege the regulation, it is sufficient, because the person has to then prima facie case has to be made by SEBI, and then the person has to raise a defense to that. Now, after considering the provisions under which people or entities have been charged, and to mind you, these are the provisions, these are the very provisions under which even a very serious matter of market fraud is charged. So consider, keeping the facts, keeping the legal position constant as it is today, if the scam of 1992, which was busted in 1992 of Mr. Harshad Mehta, was detected today, he would have been punished under these very provisions. So this is the kind of, this is the nature of proceedings that people are facing. This is the seriousness of the charges which are levied on the entities or persons who are fraught with the show cause notices under illiquid stock options matter. Now, Nikita, can we move forward to the next slide? Now, let me give you a timeline, or you may say a very brief storyline of this illiquid stock options. So this happened in year 2014 and 15. It is a common knowledge. Prior to that, there were other kinds of, large scale, not at this large scale, but still large scale scams of insecurities market, which were penny stock scams, LTCG scams, as Sir covered in his plenary session. So in 2014-15, this all happened. Later on, SEBI got to know, and as per the reports, there were more than 20,652 entities, or around these much entities, who executed trades in stock option segment. And out of this, 14,720 entities, and these are consisting of individuals, HUFs, companies, stockbrokers, and whatnot. So all these entities were found to be dealing non-genuinely by following the pattern of reversing the trades in the illiquid stock options. And SEBI initiated adjudication proceedings around more than 600 entities, and more than 100 entities. There are more than 100 orders passed in this respect by SEBI, penalizing the entities. There are some orders in which people have been exonerated. Those orders are also worth to be seen, but that is not a matter of today. But largely, by and large, the majority of the cases, and I would say overwhelming majority of the cases, SEBI has penalized. Because one thing is very clear in the mind of SEBI, that if you follow a pattern of reversal trade and there is no economic rationale of your trades, it means that the result of that trade would be artificial volume or artificial price. And to mind you, I think I missed to clarify in my earlier discussion that both of them are not required to be at the same time for the charges of fraud to be leveled. If artificial volume is there, independently, it's a fraud. If the charges of artificially raising or affecting the prices are there, independently, it is also a kind of fraud. Nikita, can we move on to the next slide? So as you see, after this adjudication orders were passed by SEBI and the proceedings were on the way, a lot of people approached SAT, and these are more than 70, 80 entities that approached SAT for challenging SEBI orders in this matter. And there were a host of grounds, starting from technical grounds to the grounds of knowledge, lack of knowledge, existence of some kingpin who connected them. But the core argument was that we do not know what happened, and we were not aware of the technicalities, because a lot of people, as I told you, are the persons from common household. They do not have any good educational background as well. I have seen, and this is out of my first-hand experience, that people who are not even literate, they have also, in their account also, these kind of things are there. So what happened is, fraught with all these challenges and appeals in SAT observed, and this was back in October 2019, before Corona. It was a matter of RSS path. versus SEBI, along with batch of other appeals, where SAT directed SEBI to consider that please hold a Lok Adalat or see some other process through which you can resolve this, because this is a sheer volume of cases. And putting it through the ordinary adjudication mechanism may create a bottleneck for SEBI, because SEBI is not only a regulator who's looking in this aspect. They have multifarious divisions. It is a very, state-of-the-art. It has got state-of-the-art infrastructure as well as state-of-the-art responsibility. And it's that's a mountainous responsibility to look after the entire securities market, where you have, at one hand, you have listed entities, at one hand, you have intermediaries, a whole set of intermediaries, which is ever increasing. And then you have got people who trade in the securities market. So SEBI has dual role. One as a regulator, as a quasi-judicial authority, and one as the administrator or the policymaker of the market. So SAT said that it might create a bottleneck. Your entire focus would be here, what you would do with corporate raiders and the sharks that are traveling in the market. I mean, those are open in the sea, out of your watch and vision. So they suggested that please come out with a Lok Adalat kind of a process or some ADR, alternate dispute resolution process, to lay down these cases to rest. Thereafter, in August 2020, it was again in August 2020 that SEBI came out with the first scheme, which is called Settlement Scheme 2020, exercising the power under Clause 26, Nikita, I guess, under which SEBI is empowered to introduce settlement schemes.
Yes, sir.
So,
Regulation 26.
Regulation 26, they came out with a settlement scheme. And this is called the first scheme. And to mind you, as I have been told, that there was a newspaper publication which said that there has been a loss to revenue of more than 350 crores, because 14,000 entities were there. If you multiply them by 5 lakh rupees, the amount comes to near about that only. So because of that, SEBI had to pursue these cases with more vigor. But SEBI did take the endeavor to launch adjudication. And as I told you, more than 600 cases were adjudicated, in which adjudication was launched. Immediately after launching adjudication, SEBI saw a big problem. And the problem was that the cases were not moving forward. There were multiple hearings, multiple requests of cross-examination, requests of bringing evidence on record, a lot of technical issues. Because, adjudication has to be as per the legal procedure. So, and principles of natural justice and reasonableness has to be complied with. So there was a lot of problem in that. So considering these, SAT suggested you come out with a settlement scheme. First settlement scheme was rolled out. Unfortunately, due to the terms of the settlement scheme 1, or due to the fact that the settlement scheme 1 contained such monetary measures as were not suitable to parties who have dealt in very few number of contracts. So therefore, this scheme did not receive a response which was expected that it would receive. Now, after this scheme, almost after 2 years, the new settlement scheme has come. And the new settlement scheme is also due to an order passed by SAT again on 13th of May 2022 in case of Shubham Singhal, which was one of the batch matters. SAT, and this time, SAT made it a point to suggest to SEBI that please make this scheme attractive so that the traders can come and settle. And apart from that, other remarks which my colleague Miss Nikita Vijay would tell you. But one thing is interesting, that SEBI opened bravely, SEBI opened up proceedings against these entities, although these were sheer in number, large in number. But thereafter, after reaching to a certain legal procedure, it was realized that it is creating a clog in the system, and later on they have to relegate it to settlement. So it is not only that SEBI wants to favor the traders, or the system want to favor the traders by settling the disputes or settling the proceedings, because SEBI is settling its own proceedings, not the proceedings which other regulators may initiate. As I told you, there are multiple regulators which have got jurisdiction in these kind of matters. One primary is the Income Tax Authority, and in fact, ED's jurisdiction is also not ousted. But SEBI is only proposing settlement with their matter. And this is a question which we'll take later on the question answer session. But for now, because both the settlement scheme find their genesis from SAT orders, and how these settlements can be availed, what are the issues in the procedural and, the nitty-gritties of it, I hand over it to Nikita to take it forward and explain you. Thank you.
Thank you so much, Ravi sir. Mr. Pavan Kumar Vijay and Ravi Prakash has already enlightened us with the background and the what has emerged, what were the reasons for the emergence of this settlement scheme. Now, I would like your focus to get on the SAT order that Mr. Ravi was talking about, which recorded that why the first scheme was not very investor friendly and why it did not get the response that it was expected to. So the SAT in the order of Shubham Singhal versus SEBI and others has recorded that the terms of settlement of the first scheme were onerous, stringent, and was not viable. And the scheme was also issued during the peak of the COVID pandemic in August, during the August 2020. So it did not get the response that it was expected to. Also, SAT in its order recorded that the penalty imposed in the AO orders was also very excessive and arbitrary on the entities who have not traded much in the shares. They have traded only one or the two trades. The reason was because under Section 15J, the minimum penalty which was quoted for the violation of the FUTP regulation was 5 lakhs. So minimum 5 lakhs penalty SEBI was imposing. Either the person has traded in the only in two trades in one contract, or even in the 10 trades or in 2, 3, 5, 10 contracts. So there was no logical rationale behind the imposition of penalty in these kind of proceedings. Also, SAT has suggested that the SEBI should bring a more refined and the improved scheme so that it should not cause SEBI to close this matter, as you all know that there are more than 14,000 entities, there are more than 14,000 matters which are still pending. Either they are in the proceedings, either they are in the appeals. So SAT has suggested that they should consider coming out with the scheme. That's when SAT opined that SAT suggested SEBI to come up with a second scheme. That's when SEBI come up with the our second settlement scheme, 2022. So now comparing the parameters which were used for the calculation of the settlement amount in settlement scheme 2020 and in settlement scheme 2022. So in the settlement scheme 2020, SEBI had only mentioned that these are the parameters on which the settlement amount is being calculated. No proper calculation or the justification of the calculation was disclosed. They just disclose that depending upon the number of contracts, the non-genuine trades, the quantum of artificial volume created, and a settlement factor of 0.55, a multiple factor of 0.55 is applicable universally on all the cases. And the minimum settlement amount was during the settlement scheme 2020 was 5 lakhs. So the minimum settlement amount also is coming from the genesis of the minimum penalty, which is provided under Section 15 of SEBI Act. Although when SEBI came up with the settlement scheme 2022, the main suggestion of this act was it should not hamper the interest of the investors and the notices who have dealt in a very minuscule contracts or the trades. Considering the same, SEBI had now changed the parameters depending upon the number of contracts that they have traded. So, as you can see, if someone has traded between 1 to 5 contracts, the settlement amount is 1 lakh rupees. If they have traded 6 to 50 contracts, the settlement amount is 2 lakhs. And if they have traded in 51 and above, the settlement amount is 5 lakh plus 10,000 per contract for every additional contract. So this is the parameters that has been changed from the first settlement scheme and the second settlement scheme. And you can see that there has been if you see the statistics of the earlier settlement scheme, then there is a drastic change in the monetary obligation over the notices for paying the settlement amount. Now going forward, there is a trending question that whether we should file the settlement application with guilt or without admission of guilt, or whether this SEBI proceedings, and if we settle the matter, whether it will have any impact on the income tax uh, income tax proceedings or not, whether income tax proceedings will be initiated or not. For that, we have culminated the excerpt of the clause 9 of the undertaking and waivers that the applicants are supposed to provide in the settlement application. I would like Mr. Ravi to enlighten us on this point.
Yes, so as you see, and the question is a $1 million question, whether settling would means an admission before other authorities, admission of guilt or not. So first thing is that there is nothing called admission of guilt. Notices would have option to settle it without admission of guilt, and which is the para number 10, clause number 10 of the undertaking. Clause number 9 is more relevant than clause number 10, in the sense that it says that the noticee is declaring that nothing here should be seen as a waiver or undertaking given by him or her that would affect their testimonial obligations. It means they still can be called by other authorities for giving testimony, which is for giving statement or recording evidence, or to take legal or factual positions. So mind you, please, this is not just a legal recourse, a legal window that has been opened. Factual position is also left open. So SEBI is settling without getting into the merits or the facts of the matter. So the notices would have both legal and factual positions open for defending the litigations or defending the claims, if any brought about, or any legal proceeding, if any brought about, if brought about by another regulator where the board is not a party. I think Sir had some point to suggest here.
Ravi, this is also right, that we should understand that when we are not admitting the guilt, it means the matter is not decided. Yes. And when income tax is coming and asking this type of transaction, then you cannot say that I have gone for settlement and yes, you have accepted. So first of all, you are not accepting the guilt. That is one part. And second, you can defend in income tax. It is just like a null and void things, where income tax has to take separate action, separate investigation, and separate proving. So there are so many defense for this. That is a part which can be discussed. Anybody can ask questions. That time we will discuss.
Nikita, over to you again.
Thank you so much, sir. Now we should, as Mr. Ravi and Mr. Pavan sir has concluded, that basically if we are settling for the matter and whether it will have any impact on the income tax proceedings or not, whether they will initiate any proceedings against the particular person, these both are independent of each other. Now moving over to what is the key pointers to keep in mind while filing the settlement application. So the timeline of the settlement application is August 2022 to November 2022. So one should not wait for the settlement for the deadline of this settlement scheme, and it would be better if the applicants who wants to settle should settle in a timely manner to avoid any last time rush. Secondly, what is the eligibility for filing for going for the settlement scheme? So basically, the eligibility is entities who have executed the reversal rate, as we have been discussing about it during the 2014 and 2015, and the persons against whom the proceedings have already been initiated. Either it is pending before the adjudicating officer or before honorable SAT or recovery officer. But the catch here is if the proceedings are pending before SAT or recovery officer, the appeal should have been filed. This is the condition that has been put by SEBI. Third, what are the requirements for filing this application? So, this application would be filed online. In earlier scheme, we were supposed to provide the physical documents also after filing the online submission. But I think to avoid the unnecessary load over physical copies of these applications, considering there are a lot of entities involved. The SEBI in this scheme has specifically mentioned that no physical submission is required for the settlement application. And along with the application, one have to submit an undertaking and waivers. The clause 9 that we were talking about in the last slide is part of this undertaking and waivers, and it has to be duly notarized and stamped. The format of this undertaking is given in the FAQs issued by SEBI under the SEBI Settlement Scheme 2022. Next, the applicant has to provide a self-attested copy of the PAN card. Third, an application for settlement as per the annexure that has been provided in the FAQs, and the basic details have been has to be given by the applicant, that if there is any SCN has been issued or not, what the name of the entity, what are the details, the basic details of the applicant has to be submitted in this application. Third point is what is the registration fee or the payment or application for the payment making the application. So registration fee for this, so basically just to clarify, settlement amount is different, and going for settlement, for applying for the settlement, this is the fees that one has to pay. So if it is a body corporate, the fees is 25,000, and for others it is 15,000. And in both the application fee, GST of 18% needs to be paid. And for making this payment, in the FAQs of SEBI Settlement Scheme, there is a separate portal, SIP portal, on the SEBI website, where you can go and where you can put your PAN card number, and you will all get all the details related to your respective matter, which includes the settlement amount that has to be paid. There is a portal where you can upload the documents and make the application as required by SEBI in its FAQs. So there has been certain procedural technical difficulties being faced by people in earlier settlement scheme also, and we have also been facing that there are some people who are facing these issues in this scheme as well. Then when they are putting the PAN card, their name is not coming, or either the data is not there in their for their respective. For that, it is advisable to either engage a consultant, because there is a separate email ID that has been given. One can make a proper representation and give their facts and whatever documents they have, make a proper representation and request SEBI to update the data if their name is not coming, or if there is any issue they are facing while filing the settlement application. So in the left side corner, you can see, you can mail the same to scheme 2022@sebi.gov.in, or you can also contact them at this number. So now, as we have discussed the background, the what is the settlement scheme, how it has emerged, why the first settlement scheme was not very attractive, and how the now we have to see whether the second settlement scheme would be that attractive for the investors or not. As we can, although the difference we see, it is the SEBI is hoping that it would be more viable for people to go for settlement, so that SEBI is not loaded with lots and lots of cases, and their human resources, their manpower, their resources are more invested in the cases which are more serious and which are more damaging. As compared to this more damaging, they can focus on those kind of cases. So
Okay.
leaving here. Yeah.
Thank you, Nikita. Thank you very much.
Thank you so much, sir.
So now the first question is how to assess whether the go to for settlement or not. So everybody should understand this part, which Ravi can add at this point. But suppose there are two issues are coming in this. Various people are asking one question, that I have not done any transaction, my broker has done. And Ravi has also raised this point. So let me just tell you, yes, this is right. The profile of people who out of 14,000, so many people are like housewife, teachers, somebody's doing job, somebody's a small, some salary class person. Various people are there. Those who require conversion, those who require the money, by paying cash, they will get the original bank balance in the bank. Now these people, somebody contacted you, he maybe lured you, he may have told you so many things. That is right that you have not done transaction, and I am understanding the option market is a market for few people. It is not everybody can buy and sell in this, or everybody can understand. So that is sure that you are lured by somebody, somebody told you what is the mechanism the broker or the agent has done. But the question is the second part. Suppose because you are the beneficiary, so you got the benefit. Now, suppose I am transferring some money to your account and you came to know, then what will you do? You will ask that who has sent this money, and you will ask. But if you are not asking, it means that you are aware of this particular transaction and somebody who has sent money, you are known to him, or you are aware that for what purpose he has sent. So here you got benefit. Now this benefit which you have received, you were silent. You should have talked that particular time that this is the transaction and I am not aware that who has done this and why the broker has done this transaction. I have not told you this. You have not raised any issue. So you were silent. So it means your concurrence was there, even if you don't know the mechanism of doing this. That is number one. Number two, whether this transaction was right or wrong, answer is it is not right. Any transaction in the anonymous system, if you know the person who is buying and who is selling, that is not anonymous system. Second is you have created that system, you have break the system. You have done something where the normalcy cannot take place. Third is you are continuously buying, selling, and reversing with the same person, and without doing anything, you are getting profit or you are getting loss, which whatever you wanted. So because so many people are coming and telling, no, my transaction was genuine. So majority is not genuine. Now the question is, if all these things are there, and what SEBI law says any artificial transaction, it is not allowed. And you are charged with FUTP, section 34142. Okay. Now under these circumstances, when everything treated wrongly towards your side, then we have to see the court, what court is saying. The Supreme Court in his order in Rakhi trading has specifically told this particular thing. Trading is allowed. Always, Supreme Court has passed an order, and you please listen carefully. Trading is always with the aim to make profit, because you want to buy something, you will not do something which can create loss. You will try to do profit. Loss is taking place, that is a consequence. But if one party consistently make losses, and that too is pre-planned and rapid reversal transition, it is not genuine. It is unfair trade practice. So Supreme Court has also decided. So under these circumstances, all these things are going against the transaction. Now, what is the way out? Now, Ravi and Nikita both have told you that earlier scheme which came, it was asking minimum 5 lakh rupees. Even you got a profit of 1 lakh rupees, you got a 2 lakh rupees, 5 lakh rupees each. So suppose there is a 4-person family, they got 1 lakh 20, 1 lakh 50,000, 1 lakh 30,000 profit by doing this transaction. So they earned only 3 lakh or 5 lakh rupees conversion they have taken place, but they have to pay 20 lakh rupees, 5 lakh each. And that was, people were not ready to go. Next is, so that's why this scheme, SEBI also realized when they got a, out of 14,000, only 1,000 plus people have applied. And SEBI realized that this is not the correct way, and that the system was also complicated. The calculation was also complicated, and the amount was very high. So under these circumstances, various people advise them that you fight and it will come. Next is 14,000 cases. Now understand, SEBI which has come out this modified scheme, which is very simplified, where the process is also simplified, where they are providing various mechanisms. So everybody should understand that SEBI is also interested to remove these cases. Now, friends, you have to understand this in SEBI, when you are going for any adjudication process, whether your matter is 1 lakh rupees or 5 lakh rupees or 5 crore or 50 crore or 500 crore, they have to follow the same process. They have to appoint adjudication officer. Adjudication officer will issue a show cause notice. Show cause notice, you will reply. Then they will give you a personal hearing. You will appear in the personal hearing. You will ask time to submit more document. All these things require time. So the entire system will block and choke. And that's why SEBI is also realizing that by doing this, they may lose face of catching hold of the big fish, because these are all small fish. Everybody knows that what is happening. So SEBI has also decided, and rationally they have come out with the simplified system. Now people are asking how to assess whether to go to settlement. My opinion is we must go for settlement. Now the system is simplified. Earlier they were asking 3 years income tax return, so many other things, various data they were asking. Their form is very simplified. Just the amount is also less, 1 lakh, 2 lakh, 5 lakh, okay, on the basis of number of transactions. And by doing this, you are settled, you are relaxed, and the SEBI will pass one order, because they are saying after receiving all these things, they will not pass individual order. As per FAQ, they'll pass single order, passing all these entities in one go, and they will settle this. So their work is also reduced and things will settle faster. Now, another issue comes, what is the position with other laws? So Ravi has explained to you, and I have also told you, the income tax, yes, it can come, ED can come, but income tax, it is, if you are saying that I'm accepting this without accepting, I'm settling this without accepting guilt, it means it is not admission. So this is the scheme, this is a chance for everybody. Out this I think 13,000 people, they have a chance, they can do. Suppose you are not going, you are fighting, then what you will gain? You will save, because as per this particular thing, 5 lakh rupees you have to give to the more than 51, but 10,000 rupees each for other cases. So ultimately, I think not more than, very few people have 100 or 200 cases to contact note. A majority people are 1, 2, 3, 4, 5, 6, 7 contact note, so they can settle it faster. Now, the answer, as a layman, suppose you are appointing a advocate like us, and how much we will charge? We will charge 5 lakh rupees. We will ask you. We will go to the SEBI for hearing. We will submit the paper. We'll make the paper and submit. So nobody will do the work of less than 1 lakh, 2 lakh, 3 lakh rupees if they are handling your case. So the best way is that go for settlement. It is the best scheme in my opinion, and everybody should try to write that without admitting guilt. And in case they require some professional help, they can use anybody, any professional in this who is doing. So the best part of this, that you settle and reduce and go for peace. Income tax may ask you, okay, you have settled, it means you have accepted. My first defense is I have accepted without guilt. Second is, they will say, why you have accepted if you have not done something wrong? So second defense is, I have accepted because of peace of mind, because of avoiding litigation, and because of the other consequences, which is not giving any fruitful result. That's why I have done this. And that is a proper defense where you can work out. Ravi, you have any other point in this?
Yes, in fact, sir, there is a little I can add or delete from what you have said. But there is one thing, I would apply a simple test. Assuming that I was the one who was involved in this kind of a case, I would have asked myself few questions. One is whether on earning profits or losses, did I inquire with the intermediary who was trading on my behalf that why such profits, why such losses? Did I read about the liquid stock options. Was I informed or I took an uninformed decision? Thirdly, is whether I have any argument of my own on which my defense would stand, or I'm just pointing out infirmity or weakness in the stand of SEBI. Like, I was also reading the section of comments here, and a lot of on other social media platforms. I was seeing that a lot of people are saying that why BSE allowed these kind of transactions to happen, why SEBI allowed illiquid stock options to function. You see, as per the law of the land, even if a shop is open, even if a store is open and the owner of store is away from the store, it does not give you right to rob the store. That is the law. Apply this example here, and let's assume even if regulator was not keeping a close eye on a liquid stock option segment, it did not confer any right to any person to cheat the market or to breach the integrity of system. Now, the ultimate defense will boil down to this point. If a party feels that they have been cheated by someone else, or their details were misutilized by someone else's PAN or account details were misutilized by someone, and then these tradings were done, that is a different kind of a matter. But if you do these kind of trades, and then you just want to point out infirmities in the stand of SEBI, let me tell you very clearly that the position has been settled by Supreme Court as well as SAT, and of course, SEBI is proceeding with these matters, so SEBI's stand is very clear, and they have made it clear by not by one order, by more than 100 orders, that they can take inference because of the nature of transactions and the pattern, the uniform pattern in which the transactions have been undertaken, that these are manipulated, and a penalty will follow. So as Sir suggested, if you do not have a kind of case where you know that you have your own defense to stand upon, you must settle, you must consider settling, and that too not at the last date, because you might miss the bus by the last date. So therefore, one must settle. There is another good reason for settling. Now, you know that there could be multiple authorities that may come after you because there is an issue of a liquid stock option. But one of the authority has come up with a settlement scheme, and they say that we will at least go back. We won't come after you after this if you settle. In my opinion, again, taking my own example, that if I was in the situation, I would have taken an objective call that out of these multiple authorities which may come in future, and the existing one in the present situation where after me there is an authority which who has already initiated a proceeding on me and that is willing to settle without admission of guilt, I would go ahead and settle. For the two prime reasons is that it requires a lot of, it certainly is a process in which a lot of mental agony is there. You have to put a lot of time and resource, and then, of course, as I told you, the seriousness of charges is really scary, because these are the charges of most heinous crimes. Securities market fraud is the most heinous crime of this market, and the punishments are also one of the severest. So, therefore, settling would be an objective call, and this is why you see that the SEBI has drastically reduced the monetary obligations for the notices. This is only to make it attractive for them to come and settle. Another angle, a third angle from which you should evaluate whether to settle or not. Now, so far, there were more than 14,000 cases which were there with SEBI. 1,019 cases got settled in the settlement scheme number 1. And that is another matter. I'll cover what was settlement scheme number 1. But now there are 13,000 odd cases. Couple hundreds of cases have been settled in adjudication and all. So leave that aside. Still, there are around more than 12,000 cases. After the settlement scheme, I'm sure that this is going to get a good response, and the number of cases which would be left would be lesser, at least not in double digits of thousands. It would become comparatively easier for SEBI to tackle the cases remaining. And then certainly SEBI, in my experience, is a regulator which takes very swift action. And they have a very high quality SOPs in place to take actions in these kind of matters. So that is another angle one must consider before deciding whether to settle or not, because once the cases would be filtered out, they can see you shining bright in the sun, and they can certainly come after you. So I think these are the angles on which one must consider the question whether to settle or not.
Yeah, Ravi, I think my answer and your answer and Nikita's answer same. So anybody has any issue, you can ask that how to do this, and till the time this is there, we can just take up some questions, okay? Because various questions we have received. Ravi, it is a duty of investor or manage control illiquid option when so who is responsible for this? The person is asking.
If a person is trading in any securities, any product of securities market, the legitimate expectation of the regulator is that the person is informed about what he's dealing into.
Okay.
So therefore, responsibility to regulate stock options is definitely of SEBI and exchanges. But caveat emptor is also a concept, a legal concept that the buyer must be aware. So that also follows here.
Okay. And FUTP was applicable to intermediaries or investors 2003?
Yes, it was.
Okay. From 72 now, this is why BSE did not annul and SODA and retain money.
Well, again, this is, as I pointed out earlier, these are the arguments which try to pull out some weaknesses in the stand of SEBI and the stock exchanges. But this will really not help the case of notices in the liquid stock option, because why did not SEBI look into the matter or BSE look into the matter at the corresponding period is a different issue. But whether after knowing it now, should they not take any action is altogether a different issue. When the fraud, as they call it a fraud, and it was so deep-rooted and pervasive, I think this is not going to help.
Okay. Why this script were not suspended, price range could also be curtailed.
Later on it was done.
Later it was done. Previously, because this is a matter of 14 and 15, so that time people are not aware. When did SEBI made rules for punishment of investors in illiquid option?
I mean, the law was already there, sir. FUTP regulations were already there, under which the traders or the intermediaries are or have been punished. The fundamental question is that ignorance of law is not an excuse that people can bring up on the record right now. This is no excuse to say that we were not aware of the law under which we are being punished.
Okay. Another point is why BSE was giving incentive to broker for doing this business. I think there may be one reason that people have done this type of transaction because of the incentive they were getting. But that is the internal management. There is a separate part now. They have whatever problem is there, they have to do this. Yes, it is right. Because next question, somebody asking what punishment are given to BSE and brokers and doing all these scams of a liquid option. I think BSE system was manipulated by brokers. So that SEBI should think of those who are doing this type of transaction. SEBI may take some action against these people. That is a future, it will be there. Ravi, will the settlement of earlier scheme will get refund of together fees or paid earlier?
Yeah, Nikita, would you like to take this up?
So basically, in this scheme, there has no mention that whether the persons who have already settled or the person who have already, there are also cases where the people have paid the penalty. But if they will now go for the settlement, if they will see the parameters of the second settlement scheme, the amount might come very, very low than the penalty that they have already paid, or if they have already settled. I think when the first settlement scheme was issued, it was written as it was issued that it was a one-time settlement scheme. So people have decided according to that. So one can so one can make a proper representation in this manner, but there has no clear mention of this. But one can make a proper representation, make their case before SEBI, and request them to come out with a way out in these kind of cases.
Okay, So in my opinion, SEBI will not refund this money, but if people are there, those who have paid early penalty, if they can make a group and go to the SEBI and request them that we were the honestly followed this and why we should be penalized. So SEBI may consider, or they can go to SET. SET can also consider. Maybe SEBI cannot change its own order, but SET can consider this issue. But if this money has gone to Consolidated Fund of India, so I don't think this is a possibility of refund. But some way out, the court or SEBI can come out. Okay. Can any person without knowledge or derivative allowed to trade in the derivative? I think we are very clear that people have trade. Agent has told, and the profile of the people I have told you, they were not the person who has traded in the stock market. Forget the option trading. Option trading is a very specialized thing that people have not traded. So these are the lured by some people. Will the person who have the already paid 5 lakh, I think this we have told, who are the investor according to SEBI? I think this is that is everybody knows. Broker and broker is not the investor. But if you somebody is asking who are the investor according to SEBI, are BSC and brokers are considered to be investor here. So if the broker has done transaction in his own account, then he's an investor. SEBI, BSC is not a part of this, so he cannot. There's no question of they are the investor. Broker has a two role. One is intermediary, one is own pro trading, so that can be considered. What will be the penalty charge on 2/6/2022 by SEBI and NSE for punching? I don't think this is connected to this particular thing. Ravi, this is interesting. A order imposing penalty of 5 lakh. Entity appealed in SET and applied under settlement scheme. As per applicable criteria, amount is 1 lakh. Is settlement possible and how will pass settlement order?
Yes, settlement is possible in that situation. In fact, the same is written in the FAQs that if adjudication proceedings are culminated and your matter is in recovery, then also you can file this appeal before SAT and get remanded to the settlement. Maybe SEBI might impose some legal cost over and above 1 lakh rupees, but that is also not clarified in the scheme. They might not even levy any kind of legal cost, and they may take this 1 lakh, depending on the slot in which you fall. They might take the case and settle it. So it is possible. I mean, the answer is given in the SEBI FAQs only. Nikita, if am I right?
Yes,
am I
sir.
right? Yeah.
Yes, sir, absolutely.
Yes.
Okay. Can any person be punished on ex post facto law?
Well, this is a legal question. Ex post facto law, legal answer is no. Ex post facto law cannot be applied ex post facto, but there is no question of ex post facto here because the regulations existed very much at the point of time when these reversal trades were done. And this has been argued till Supreme Court approved from there. So, I mean, SAT has also upheld it. So it's no more a res integra. There is no element of ex post facto law being applied here.
Ravi, this is one question. Is ED, what is the timeline for initiating action?
So, because proceedings of money laundering are criminal in nature, there is no such time limit on ED proceedings, although each and every agency, including SEBI, and this is now settled by SAT in HB Stock Holdings, the case of HB Stock Holdings, and the recent case of Shruti Vohra, that the authorities have to act with some kind of alacrity, and there must not be latches and inordinate delays on the part of notices, because passage of time results in a lot of diminishing of the capability of raising a defense. People die, records lost, people change employment. So, it is difficult for people to raise defense later on. But speaking from the statute, there is no bar or limitation provided or written in the statute that beyond these many years, ED or SEBI cannot take action. Such kind of a bar is seen in income tax because the objective is to collect the revenue. Here, the objective is to punish, or the objective of PML is to attach and confiscate and imprison the people. And the objective of SEBI Act is to, ensure that the market grows. growth of securities market and protection of investors. So there is no time limit which is written in the statute, sir.
Okay. What is the precedent? Whether other authorities like income tax and ED do come after you after settlement means what are the chances?
So in illiquid stock option cases, I mean, those who are from Delhi, those who are in the audience from Delhi, they would know that many of them would have been summoned 3-4 years back in Jawaharlal Nehru Stadium before income tax officers, and investigations were going on in these kind of matters. Investigations can be launched in these kind of matters. And I'm speaking from the news articles which have been published recently by some ex-officers and ex-officers of SEBI as well as from income tax. They have clearly stated that income tax had got jurisdiction and they may come after you. And that's independent from the settlement.
Okay. So Ravi, there's another point is the person is asking that chances. So no doubt, tax and ED can come to you, but you have a defense. Defense is that you are not accepting guilt. So somebody has charged and you have paid amount for fees, and then you can rest for this type of things to avoid further investigation. If somebody is asking whether income tax and ED cannot call you, they can call you. But in my opinion, the transactions are small in number, that is more. So there is a possibility that they can catch hold only the big one. So for big one, they can take legal advice on this particular issue, and they can understand that what are the consequences of this. In my opinion, the small transactions or a small amount are not the question of worry, but big amount is a question of worry, which they have to protect themselves properly and understand that what defense they can take. So they have to put two defense. One is the defense on the transaction itself, that this transaction you have done in genuinity, because so many issues are there, whether I have done 1, 2, 3 transactions, but it is not matched with the same time. It has matched with the time. So you have so many defense also, which you can take that this is not the transaction. So first is the main authority SEBI is accepting this point that you have done transaction, but I'm not insisting that you have done something wrong. Okay, this is one part. Second part is that you have so many other defense which you can try to do this. So it is better that big transactions must take legal advice and then they go for settlement. But for them also, settling is the best part. Keeping open. Now this is another point. The name is, your name is there. Show cause notice is there. The list is there. SEBI can or ED can take that list from SEBI, and then without this also they can do something for you. So here, if you're not going there, then your all 3 agencies will after you. SEBI also, the income tax and ED also. But if you are settling here, then there is a chance that you can say that SEBI has not proved anything, which is the main authority, and which has not done anything. They have not found anything wrong in my conduct, but to settle this amount just for the sake of peace. No law, there was 2018 law was made. I think this is, in case order is passed by AO during June 2022 and pending with recovery officer, can we still file appeal and file application under the scheme? Yeah, Ravi?
Yes, sir. They can.
Okay. I'm not taking personal comments on somebody. And please request to all the participants, please stick to the topic. Don't go beyond this. Will the earlier settler will get back their money? Answer is same. It is because I don't think they will get. But if they can approach SEBI and they can file application combined in set, they may get something. How shall I avail the settlement when my PAN number is wrongly mentioned in the notice and also in the settlement scheme data? Nikita?
For this, one can approach the designated email that has been provided for the scheme, and give the proper documents and facts so that they can update their data accordingly. SEBI can update their data accordingly.
Somebody is saying income tax timeline has already over. Whatever had happened has already happened. That is also one defense people can take. Okay, because they say time bar. Is PMLA also recently there was a Supreme Court order? Ravi?
I think that order answered all the questions against all the defense lawyers. I mean, I hope a reference is being made to the order which was passed recently, 1 or 1.5 months ago, in which Mr. Sibbal, Mr. Singhvi, all of them appeared. And that order settles a position that, there is no time limit for ED proceedings. It has only thing that has to be ensured, as I said earlier, that there should not be any inordinate delay or extreme laches in the conduct of agencies. That is the only thing.
Okay, now I have some few questions which we have received earlier. I have not done any transaction. My broker has executed the transaction. Now what should I do? Ravi?
Well, this is not a defense because if your broker has done the transaction, as you rightly said earlier, beneficiary theory, if applied, it can be clearly seen that the noticee is the beneficiary of those transactions. Merely saying that I have not done the transaction would not suffice. They have to show that what steps they took if they were aware that broker has done the transactions without their approval. And if the broker has done transactions with their approval, they have to own it. And if it was without their approval, what steps they took in law to prevent it or to seek any remedy against those actions.
Okay, Ravi, in the undertaking, they have mentioned nothing in the settlement order shall preclude any other person from pursuing any other legal remedy to which such person may be entitled against me or us as a per law. So they are saying that if you have gone for settlement, but tomorrow income tax or ED is taking something, then they are not restricted.
Yes.
Okay. Okay. Now, they are also, and under undertaking, they are also saying that you will not file any case, any other thing. You cannot settle, it's always settled. You have no.
Yes.
Okay. Okay. Contact note receipt from the broker and trading details. Receipt from SEBI does not match. What to do?
Well, this is a case where a defense may be taken that the records which are relied upon by SEBI are not the one which are with the party. And if the record relied upon by SEBI are the correct ones, but the broker has given the notices or persons falsified records, then that is a ground. I mean, that becomes a fightable case. But in the nutshell, the notices would be required to prove that they did not have any knowledge with regard to this fraud. That is the question, that is the threshold the notices are required to meet.
Okay. Ravi, I had no knowledge of the trade. These were done by my broker. I had no knowledge that he was committing any violation of law. Am I still liable?
Well, Nikita can give an answer after I give a short answer to it. This is the argument taken in all the cases. I mean, across the board, you would see, sir, that this is the argument taken, and this argument has been rightly rejected by the courts because one can say today very easily that I did not have any knowledge. But when the court asked pointedly the appellants that what step did you take, no one had any plausible answer to give to the court. I think Nikita can share her views on this.
So in both the orders, the order that has been passed by the SAT in IRS is SAT and the Shubham Singhal, the recent order, people have made their argument as Sir said, but SAT has categorically stated that the violations are there in these kind of cases, and one cannot come up and say that they do not know that they were not doing the transaction, the broker was, and they have not taken any consequent steps to stop it or to challenge it, and they have received the money or paid the money for those transactions, but nothing has been challenged. The transactions were done from their bank accounts. Nothing has been challenged.
Okay. Ravi, if date, time, quantity is different, will it be synchronized trade?
No, that is not synchronized.
Okay, and now rapid round is, I'm starting because time is short and we have more questions.
Yes.
To what extent the broker is responsible?
To what extent the broker is responsible? I mean, to the extent that the broker conducted trades in illiquid stock options, not beyond. Investor would be liable for his part.
But if broker is a part of this?
Well, certainly, then he's the kingpin of the fraud.
Okay, what is the responsibility of stock exchange?
Stock exchange, I think a responsibility cannot be fastened. It would be like, I mean, punishing or blaming a stock exchange would be like blaming the store owner whose shop has been robbed.
Okay. Is it not the system failure?
Yes, it is. But more than that, it is a fraud which reached to retail level.
Okay. Nikita, after making the online payment, it is compulsory to send physical form of Form A to other document to SEBI?
No, sir.
Whether the noticee who have already paid the penalty will have to allow to avail the benefit of the scheme that we have given answer.
We have already covered.
Can applicant make a detailed application to SEBI explaining their case and mitigating factors?
There is no bar they can make.
Okay. Whether now the application you are filing, can you write any other thing in this for future?
Yes. Yes. It is not barred.
So it
They have
is
not said don't write.
So it is advisable in case any authority is coming, then you can write this also. So for that, you should take a legal advice on this from the expert. Okay. Whether under the scheme, new scheme 22, SEBI can take lenient view based on the mitigating factor showed in the settlement application. I don't think when they are 1 lakh or 2 lakh or 5 lakh, that is a whatever other mitigating factor you are showing, this will not be helpful because that is they have given a formula, you have to follow the formula. Whether settlement can be done without admission of guilt under the settlement scheme, answer is yes. The provision pertaining to settling the proceedings with guilt or without admission of guilt under ordinary settlement procedure. Maybe
The procedure of settling without guilt is usually one has to pay some premium for settling without the guilt. Here in this settlement, there is no such element. I mean, you can settle without admission or with admission. As you rightly pointed out, people must make their submissions at least along with the settlement application for future protection.
So if I'm, is there any extra penalty? If I'm
not here, not in
Not
the
here.
scheme, new scheme, but
Yeah.
ordinary settlement regulation requires payment of some extra premium if you are going without acceptance of guilt.
So the best way is you should go for without admission of guilt and write the mitigation factor. And for
Yes.
writing mitigation factor for future protection from other regulatory authority, you should take legal advice. Okay, legal help. Provision pertaining to without admission of guilt under settlement scheme. Okay, what are the parameters taken into consideration by SEBI while calculating a settlement amount? How an applicant can verify the amount?
Well, this is a very long drawn question because for different kind of violations, different circumstances, different parameters come into play. For this settlement scheme, parameter is clear: 1 to 5, 1 lakh rupees,
1 lakh.
6 to 50, 2 lakh rupees, 51 and above, 5 lakh rupees is the base amount, and 10,000 per contract. This is the parameter for settlement scheme 2.
So suppose I have the 5 lakh penalty on a 51 contact, and then I have a 100 contact also.
Yes.
So I have to pay 10,000 multiplied by 100.
Yes, that is the situation. Now, interestingly, sir, in settlement scheme number 1, the minimum base amount was 5 lakh rupees. But if you 1,019 entities participated in settlement number 1, which ran till December 2020. And total amount paid by 1,019 entities is more than 87 crore rupees. So if you average out these 1,000 people for 87 crore rupees, on average, people have paid more than 8 lakh rupees. Here, these are the same people who are given opportunity to settle for 1 lakh now. So I think this tells you what kind of drastic measures SEBI has taken to make it attractive.
Okay. Okay. Will SEBI grant the extension of present settlement scheme?
I don't think they would be giving any extension. Time is sufficient. They have given till November.
Okay. Can settlement amount be reduced? No.
It is not said. No. Primary answer is no, and one should not endeavor for that.
Whether settlement scheme 2022, dil mange more na. So
Yes.
whether whatever scheme is there, you have just now told that 8,75,000 was the average, whether if you have done whatever transaction. So here they have reduced to, so people should follow. Will SEBI grant the extension of, or this is there? Whether settlement scheme 2022 available to an individual who has done purchase and sale transaction delivery based share, who has taken the given such delivery, but such transaction were fictitious. I don't think that is there. If you have not received a show cause notice under this, if you are not the part of this 14,000 show cause notice, this is not applicable to you. You have to go to normal settlement process. If someone feels that their case is strong on merit, whether they should opt for settlement or go for adjudication. Ravi.
One has a very strong case on merit, sir. And if I told the parameters earlier, if they have their own defense to stand on, they can go for adjudication.
Okay, Nikita, applicable to GST, whether it will be paid on to the application fee or the settlement amount.
So the GST is payable on the application fee at the 18%.
And the settlement amount?
No, sir. Settlement amount is fixed.
So I have to file application if I'm a corporate 25,000 rupees and if
Yes, sir.
15,000 rupees.
15,000.
That is enemy application. And then second, they have given a link also. I can check my
Yes, sir.
transaction because they have done the calculation on that basis. If the notice is availing the settlement scheme, whether it is the obligation to inform the adjudication officer upon the successful filing of application.
One should.
It is advisable.
Yeah, I think this is a normal process because though they will get the information, but it is advisable to inform them. Okay, now some question connected to SEBI investigation proceeding in the liquid stock option matter. Why brokers are going scot-free and investors are facing action by SEBI? Ravi.
Brokers are not going scot-free. Brokers have paid, I think, the maximum amount of penalty in settlement scheme 1 was paid by brokers. So they have not got scot-free. The thing is that brokers have taken an objective call and they have got their matter settled in the scheme number 1. Most of them.
Okay. Okay.
Yes.
Nikita, how shall I avail the settlement when my PAN number is wrongly mentioned in the notice and also settlement scheme data? I think this we have given answer.
Yes, we have given.
Okay, now for an PAN correction already been mailed to adjudicating officer and SEBI settlement scheme, but no one is replying. What to do?
Well, I think in these kind of cases, you should seek some advice. I mean, some assistance in how to take it up with SEBI.
And but simultaneously, they can write settlement 2022 email. They can send and ask them.
Yes, but they have sent. They are not receiving any response from that ID, so they can take it up with SEBI. They engage someone who can bridge this gap between you and SEBI.
Okay. Recently, there was an order where payment was not received and a favorable order from AO.
I'm sorry, sir.
Recently, there was an order where payment was not received and a favorable order from AO. I'm not clear what. In all the cases, content note are not matching with the show cause notice. So I think if I'm adding both the question of this same gentleman, so if the show cause, if the contact note are not matching, then you can get relaxation. How much penalty was paid by broker? We don't have that data. If number of contracts are different in SEBI side from investor record, what to do? Ravi.
I mean, first one must go for reconciliation of record with SEBI.
Okay, so this is for everybody. SEBI has given you link. So you put your PAN number, your contact note will come. You match with your contact note of the broker. And if there is any difference, you talk to SEBI and there's a number they have given and try to settle this issue. But you have to do faster. You should not wait for the last day. Then you will not get the desired result. So after doing this, then you can proceed for further information. Delay in initiating proceeding by SEBI investigation concluded 2007. No direct evidence against the applicant, can still penalty be levied. What benefit the applicant can get?
Direct evidence is not a sine qua non for levying of penalty. Preponderance of probability is now established concept. So, and we rest assured, I think we have told in the presentation that what is the evidence SEBI is basing their charges on. So there are sufficient evidence. If somehow one feel the gentleman who has raised this question, he feels that he has a case where no evidence of wrongdoing is there, he may take it up in adjudication.
Okay. Ravi, fast, what initially issued show cause notice 500 entry, not to the other entities?
I mean, the reason cannot be speculated, but it is permissible for SEBI to do it in a manner of distribution waterfall.
Okay. How many entities were penalized between 5 lakh to 10 lakh to 11 lakh, 20 lakh, 21 lakh to 25 lakh?
There are total 1,000 entities who opted for settlement. And then data of, statistical data of how much penalty has been levied can be seen from the annual report of SEBI. But you'll have to compile all the orders and see who was punished with what penalty.
What is the rationale behind imposing a penalty by SEBI?
Because the people who have done illiquid trading has interfered with integrity of system, and they have created artificial volume.
Apart from adjudication proceeding, can SEBI also initiate proceeding under other provision of SEBI Act? If you can share a few examples.
Yes. So suppose SEBI has levied a penalty of 5 lakh rupees, but the person is not paying that penalty, prosecution can be launched. Recovery can be initiated.
But they cannot do this for other violations. SEBI cannot start any proceeding other than this.
Yes.
They can start proceeding consequential to this order.
Consequential to this order. That's correct.
Okay. HUF executed the transaction during the investigation period. Upon receipt of the settlement notice, the HUF got dissolved. What is the responsibility to, who is responsible to pay the settlement amount? Nikita.
The Karta of the HUF.
Even the HUF is dissolved. Okay.
Yes.
Okay, Ravi, what are the tax, interest, penalty, prosecution, exposure in respect of fictitious profit losses claimed by the person from derivative transaction covered by SEBI Settlement Scheme?
I think if the fictitious gains or losses are established, fictitious losses are established in tax statute, it can go up to 3 times, 5 times, and penalty and interest can be levied separately. So sky is the limit. One has to make specific reference to the provisions of Taxation Act.
Okay. Okay. Next is whether opting for SEBI Settlement Scheme would operate against such person in tax proceeding, and which are the courts available to avoid the adverse tax consequences even after opting a settlement scheme. I think that we have given answer clearly that you do following things. Number one, you go for without admitting the guilt. Number one. Number two, you write the mitigating factor. These two things will help you. But how to write the mitigating factor? That you should take advantage of some expert advisory if your case is higher amount. Okay, or when you are coming on the bracket of the bigger thing. So that is one thing which you can take advantage of. What argument can we take in the income tax?
Well, that it was settled without admission, and second is that your argument has to be based on the factual position of your case, which would obviously be defending the loss or profit, saying that it's genuine, not artificial.
And you can also say that because the expert authority has not levied penalty on the basis of admission of guilt, it is without admission of guilt on settlement scheme, and settlement scheme and the adjudication proceeding are totally different. Like you are doing every day, you are violating traffic rules. So they are just compounding as an immediately on the site. So that is not a stigma, that is not there. So the best way is that you can argue that I have settled this because of peace of mind. If the security transaction tax is paid, will it be help in providing trades for genuine?
No. Security transaction tax is consequential to doing the trading. You don't have to pay it. It is deducted automatically from the consideration. So that was always be there. But you have done transaction in a specific manipulative pattern. That's the fraud.
Okay. Why a limitation act applies to investor, not on SEBI?
Well, limitation applies to SEBI as well, just that there is no limitation written in the law for SEBI, because as a regulator, they may have to investigate cases of deep-rooted fraud. This public would be sitting on the shoulders of regulator and bantering on their head if for the sake of limitation, regulator could not unearth frauds like Harshad Mehta and the frauds that followed those episodes. So therefore, limitation is not there on regulator.
We have, I think we have 40 questions and then 33 questions we have received yesterday, 73 questions, all we have given a reply. Few questions which are connected to personal attack, personal questions, not connected topic, I have not covered. So thank you very much to all. Any questions, any issue, you can contact us. You can write to us, and the email address is in the banner which we have sent you the invitation that is there. You can write to Shivam Singhal, and we will give you a reply, because some questions after our discussion may emerge. So you can write to us. So Ravi and Nikita, one comments for closing. What is your view of the, so Nikita first, about the settlement scheme? What should I do as an investor?
As an investor, I think I think the settlement amount has been reduced a lot, so one can seriously think and opt for the settlement.
Okay, Ravi, your
Yes.
things, and yeah, am I not? So what in a closing remark? What do you say?
Yes. So one must consider settling, but without admission of guilt and with proper protection for future. They must write down the right kind of mitigation factors to SEBI so that it is not held against them. Secondly, what is also required to be seen by notices is that they do not wait till the end for wait of another settlement scheme, because they never know what is going to come in future. After this, cases will be filtered out because this is so attractive. I mean, as directed by SAT, SEBI has made it attractive, in fact. And those who would not settle and would still be in adjudication, SEBI is going to move very, very fast against them, because number of cases is going to reduce drastically after the settlement scheme 2 gets over.
Okay, so my view is, friends, as a investor, as a legal person, my advice to all the investors, they should go for this scheme. This scheme is the lowest, cheapest in all aspects, and less cumbersome, and the form and other things also easy. Previously they were asking 3 years income tax return, various other documents. People were worried, so they have simplified this. This is number one. Number two, if you are going for this type of thing, so to write to this, first you go for without admitting guilt and write maximum mitigating factor which you can do. But doing this, the best part is that you just must check by adding a PAN number and see that what are your transactions, and see the 3 things: the same party, same amount, and same time. If anything is missing, that is also one mitigating factor for you. So combining all these things, and not knowing this, that your broker has done this and somebody has done, and the amount is very less. These are some factors which you can work out, and you can say. If you think that other things are not matching, then you may have a genuine transaction which you can argue well. So with these things, if you can follow, I hope that it will be a good thing. And for any query, any issues, you can contact Ravi and Nikita. They can assist you, or any question you have, you can write to us. We will reply you without any obligation. So that is the knowledge sharing which we are sharing every Friday, every month, and continuously following since 2020 when the COVID started. Now continue this journey. The next program we are organizing on MCA version 3, where the various new things have come in MCA. Incorporation is very simplified. Incorporation had added so many value added things. We all will discuss in next meeting with the SEBI, with the MCA Joint Secretary, Mr. Manoj Pandey. Thank you very much. Thanks for joining. Thanks, Ravi. Thanks, Nikita. Thank you.
Thank you so much, sir.
मेरे रूम में आना.